Welcome to Introduction to International Criminal Law, the first of many classes on international criminal law by Nasser Fizi, Senior Lecturer in Law. I want to start by asking 15 questions as discussion points or food for thought. And I want you to think about this deeply and think about what your answers are today and during the course. 1. What is international criminal law? 2. Why is international criminal law difficult to define? 3. What are the general characteristics of international criminal law? 4. What past and current examples demonstrate where international criminal law has been applied? 5. What is an international crime? Six, what are the main international criminal offences? 7. What are the sources of international law? 8. What is the relationship between international law, international human rights law, international humanitarian law, and international criminal law? 9. What are the sources of international criminal law? 10. What are the key aims and objectives of international criminal law? 11. What are the key domestic and international institutions involved in international criminal law? 12. What are the key arguments in favour of international criminal law? 13. What are the key arguments against international criminal law? 14. Is international criminal law under attack? And 15. What are the key reforms of international criminal law? So what is international criminal law? Definition: international criminal law is a branch of public international law that deals with the prosecution and punishment of individuals who have committed serious crimes that affect the international community as a whole. These crimes are often termed as core international crimes, and they include genocide, war crimes, crimes against humanity, and aggression. There are unique aspects of international criminal law. Let's just mention two. International criminal law is unique because it imposes individual responsibility for violations that traditionally fell under state accountability. And the establishment of institutions such as the International Criminal Court, ICC, has significantly contributed to the development and enforcement, to some extent, of international criminal law. There have been a number of historical points that have developed international criminal law. One, the post-World War II ICL, international criminal law, began to take shape after World War II with the establishment of the Nuremberg and Tokyo trials, which held individuals accountable for crimes such as war crimes and crimes against humanity. Moving decades later, you've had the ad hoc trials in the 1990s. Further developments through the ad hoc trials such as the International Criminal Tribunals for the former Yugoslavia, ICTY, and International Criminal Tribunals for Rwanda, ICTR. And then you've had the adoption by many countries, the Rome Statute 1998. The Rome Statute of 1998 formally established the International Criminal Court, marking a significant milestone in the evolution of international criminal law. But I think we should look at why is international criminal law difficult to define. There's a number of reasons. One, the involving nature. ICL is to some extent codified in a single universal document, the Rome Statute, but is derived from various sources, including treaties, customary international law, and judicial decisions. It's constantly evolving. Two, you've got this idea of dual nature. It borrows elements from both international law and domestic criminal law, creating a hybrid legal framework, which we'll be exploring in future classes. There's been a recent emergence before the establishment of modern institutions like the International Criminal Court. The prosecution of international crimes was sporadic and ad hoc. And then you've got this idea of the continuous development of international criminal law, the continuous development of its jurisprudence, as seen in the cases such as the prosecutor versus Tadic, and we'll be exploring international criminal cases in some of our classes, which highlights the evolving character of international criminal law and its jurisprudence. There are a number of general characteristics of international criminal law, and I've just mentioned 3 here. The idea of it being a serious crime. International criminal law addresses the most serious crimes that threaten the peace, security and well-being of the international community. You've got this idea of individual responsibility as a characteristic of international criminal law. It emphasizes individuals' criminal responsibility, holding perpetrators accountable regardless of their official position or nationality. And then you've got this idea of universal condemnation. Crimes are universally condemned and prosecuted under international jurisdiction, assuming the country and the nation has ratified the Rome Statute. And this moves on to the issue of enforcement and codification of international criminal law. Just look at the enforcement challenges for one moment. ICL lacks a universal enforcement mechanism. There's no international criminal law army or police force. While institutions like the International Criminal Court provides a forum for prosecution, they rely on state cooperation for enforcement, heavily on state cooperation for enforcement. Major powers have not ratified the International Criminal Court and or placed sanctions on members of the International Criminal Court. And there is therefore arguably, but for some, no universal court. And then let's look at the issues relating to lack of uniform codification. ICL relies on a combination of treaties, customary international law and general principles of law. This dynamic nature makes international criminal law adaptable, but also presents challenges in ensuring consistency and predictability. And there's no uniform codification of international criminal law according to some, and it's made up of rudimentary rules which are not fixed but are evolving, and some people argue that therefore they're not fit for purpose. There are examples of international criminal law in action, and these are considered to be successes. The idea of the Nuremberg and Tokyo tribunals, the first international tribunals to prosecute individuals for crimes against humanity after World War II. You've got the ICTY and the ICTR. They played a pivotal role in addressing atrocities committed during the conflicts in the former Yugoslavia and Rwanda, some may argue. And then you've got the idea of ICC cases that passed and ongoing. Prosecutor versus Al-Mahdi, involving the destruction of cultural heritage sites in Timbuktu, Mali, and the ongoing prosecutions of individuals for crimes of genocide and war crimes. So what exactly is an international crime? You've got the definition from the preamble there from the International Criminal Court statute, which refers to the most serious crimes that are of concern to international community as a whole, and recognises that such crimes threaten the peace and security as well as and well-being of the world. And then you've got this idea of recognition. These crimes universally recognised and often involve widespread or systematic conduct, and the core crimes are genocide, crimes against humanity, war crimes and aggression. And this idea of dual prosecution can be prosecuted at both the domestic and international level by inside the country or on the International Criminal Court. And it's based on this idea, the principle of complementarity, assuming it's respected by the countries. And then there are 4 main international criminal offences. Genocide, acts committed with the intent to destroy in whole or in part a national, ethnic, racial or religious group. Crimes against humanity, widespread or systematic attacks against civilians such as apartheid or enslavement. War crimes, which are those serious violations of the laws of customs of war, the laws of war, international humanitarian law, including targeting civilians or using prohibited weapons. And then you got the crime of aggression, the use of armed force by states against the sovereignty, territorial integrity or political independence of another state. And there are a number of sources of international criminal law, and there are four that I mentioned there: treaties, international conventions, international custom as evidence of general practice of laws, the general principles of laws, the common principles in major legal systems, and then you got this idea of judicial decisions and scholarly writings, and they all form to some extent sources outlined in Article 38 of the Statute of International Court of Justice. And what's the relationship between international criminal law and other branches of law? So international law, this provides the framework for relations between states and establishes the legal basis for prosecuting international crimes. International human rights law, that protects individuals from state abuses and ensures, say for example, fair trials rights in international proceedings. International humanitarian law, also known as the laws of war, they govern the conduct during armed conflicts and criminalize violations such as targeting civilians or using prohibited weapons. And then you've got its relationship with domestic laws. This complements international criminal law by prosecuting crimes at the national level within the country when international mechanisms are unavailable. And then you've got this issue of the key aims and objectives of international criminal law. You've got 5 there: punishment, ensuring that perpetrators of grave crimes are held accountable; deterrence, preventing future crime by establishing accountability; reconciliation, facilitating post-conflict healing and restoring social and societal harmony; victim vindication, recognizing and addressing the harm caused to victims as seen in the prosecutor Al-Mahdi. And then you got the issue of historical record. Documenting atrocities is important to prevent denial and distortion of facts. And then let's look at the arguments in favour, and then the next slide, arguments against international criminal law. Well, the ones in favour of international criminal law are these: 1, accountability. International criminal law ensures that individuals, regardless of rank or status, are held accountable for serious crimes as seen in the prosecution of high-ranking officials and heads of state like Slobodan Milosevic and Charles Taylor. You got the arguments in favour of international criminal law, the idea of deterrence by establishing individuals responsible. International criminal law serves as a deterrent for potential perpetrators. 3, victim justice. International criminal law acknowledges and addresses harm caused to victims, ensuring their voices are heard through mechanisms such as victim participation in international criminal court proceedings. 4, universal standards. This provides a framework for universal norms against crimes such as genocide and war crimes. 5, strengthening international peace. International criminal law promotes global stability by addressing crimes that threaten international peace and security. Remember, each of these are arguments in favour of international criminal law. They should be backed up by reference to academic sources, authorities, and judicial comments. But there are also key arguments against international criminal law. The selective prosecution. Critics argue that international criminal law disproportionately targets individuals from weaker states, while powerful states remain immune. Enforcement challenges. International criminal law relies heavily on state cooperation, which is often inconsistent or absent. Think of those international criminal court warrants that left unenforced. 3, resource intensity. Investigations and prosecutions under international criminal law require significant time and financial resources. Who's going to pay for these investigations and prosecutions? Political influence. Some argue that international criminal law is influenced by geopolitical interest, undermining its impartiality. And then you've got this major issue of sovereignty concern. International criminal law interventions in domestic matters can be seen as infringing on state sovereignty. Think about recent conflicts that have taken place and the criticisms levelled at the International Criminal Court. And there's a really important question that needs to be addressed here. Is international criminal law under attack? And is international criminal law dead? Arguments in favour saying yes, declining support, politicisation and non-cooperation. Declining support. Some powerful states, including the United States, have withdrawn or refused to ratify the Rome Statute undermining the ICC's authority, and even issued sanctions against International Criminal Court members. The politicisation, accusations of bias and selective prosecutions have led to decreased confidence in ICL, and non-cooperation, states refusing to comply with International Criminal Court warrants, highlights enforcement challenges, and also highlights the issue that the International Criminal Law is dead. No is the argument. Global ratification. Over 220 countries have ratified the Rome Statute, showing broad support for international criminal law and the International Criminal Court. Continued prosecutions, high-profile cases such as those involving child soldiers and cultural heritage destruction reflect the ICL's relevance even today. And then you've got this idea of victim-centered justice. The ICL, the ICC, victim participation mechanisms continue to gain recognition. And let's assume you want to revive and continue international criminal law. And therefore, what are the key reforms? You've got improved enforcement, enhancing state cooperation mechanisms to execute those warrants and gather evidence, increased funding, securing adequate resource to ensure efficient investigations and proceedings, not just in those weaker states, but in those states which are powerful, addressing bias, ensuring impartiality in prosecution by adapting transparent procedures, expanding jurisdiction, addressing crimes such as environmental destruction and terrorism under international criminal law, because instead of restricting it to those 4 international criminal crimes. And then you got the strengthening of victim participation, broadening victim access to justice and reparations. Remember, read widely, critically think and reflect on the topic, consider both sides to an argument and different perspectives. Refer to those academic authorities, judicial comments to strengthen the arguments. Consider the weaknesses and strength of those arguments, and develop your own opinion on those 15 and more discussion points. I hope you found this class interesting and useful. Thank you for watching. Subscribe and follow for more.